So the attorney's going to have to say he has to come up with this belief system all of a sudden that attorneys don't have a belief system. Attorneys use precedent and case law. They say, the attorneys have to say, well, I don't believe this, but if you go back to the Scalia Court of 2006, the Scalia Court, or the Roberts, well, it's called the Roberts Court. The Roberts Court, ruled in this manner, and Scalia wrote the opinion for the court. So like I said, attorneys have to use what like somebody superior to them believes, or what somebody above them in their society established as the position of the Supreme Court. So when we establish our positions, we're supposed to be the representative of God. So when we utter something, it's supposed to be like God uttered something. So our belief outranks the lawyers, because they have to base it upon an opinion of a court. So they can maintain their position. We have a belief. They maintain positions because they're governed, and that's what govern means. To govern something means to maintain a position. To govern something, like a governor on a carburetor or a governor on a boat, it steers it. So they have to maintain a position, and the Supreme Court and the Roberts Court, maintains this position that you can't do this or you can't do that. It's like, well, that's just lovely that that's the position that the Supreme Court of the United States ruled, but that's also saying the Supreme Court of Mexico, or the Supreme Court of Paraguay, or the Supreme Court of Canada. Who cares? It's the Supreme Court of the United States government. It's the Supreme Court that makes a ruling between the president and the Congress. The Supreme Court is not supposed to make a ruling between me and Bob, because that's not within their jurisdiction. I'm not under the Supreme Court's control. I'm not under the rule of the Supreme Court. I'm a man. Bob's a man. If Bob's got a problem with me, we take it to a trial by jury. We go before 12 other, men and 12 other, other members of our society. We don't go to the Supreme Court. And like I say to folks all the time, even if you do go to the Supreme Court and you take all that stuff and you win, yay, you always see what the Supreme Court says. Now that we ruled in this guy's behalf, it goes back to the court of the original jurisdiction, like a federal district court. And then the issue gets brought up in federal district court, and now the federal district court has got a good opinion on how he should rule this time. So when it goes back, the ruling comes back to the Supreme Court of Alabama. That's why John Wilkinson told me that. He said, you know what, you could get a ruling from the Supreme Court of Alabama. It could take you up to 12 years to get a ruling. And what's going to happen is going to go back to the court of original jurisdiction, family court. And the family court judge could tell you, oh, that's a lovely opinion that you got from the Alabama Supreme Court. But you know what? You could tell the Supreme Court to go F off, because this is my case. You're in my courthouse. You're in my jurisdiction. You're in my realm. And I'm telling you, F off. So you just wasted all your time winning an appeal. And that's exactly what the man who is the head clerk of the appeals court for Alabama said to me, and he's been doing it since 1975. He's a deacon of a church. He's the president of the Court Clerks of America Association, and he teaches this at a university down there, at a law university down in Alabama. So if he's telling me it's a sham, it's a joke, it's a total waste of your time and a waste of your money, I'm not going to argue with this man. This man's an expert. When somebody like a doctor tells me, hey, buddy, you got a ruptured diaphragm, and we got to go in there and web you up and put all your pieces back together again, I say, okay. And like I said, it was funny, the anesthesiologist knocked me out because I watched like a whole bunch of YouTube videos of what they want to do to me, and I was giving them advice on how they should patch me up, and they were like, that's enough of this guy. Knock him out. Man, they knocked me out with a shot. They didn't even wait to gas me, man. They knocked me out with a liquid tranquilizer. It was pretty funny. But there's like, that's enough of this guy's opinion on how we should do our job. We got this covered, buddy. And that's basically, like I said, what a district court judge will do, too. It's like, that's great. That's a great opinion from the Supreme Court of the state, the Supreme Court of the United States government. That's just lovely. That's a lovely freaking opinion. But you know what? I'm going to do whatever the hell I want. It's just like a trial by jury. The jury could say, well, that's a lovely code, and that's a lovely law that we have here in Alabama or Virginia. But you know what? We're going to do jury nullification. We're going to go off the board with this one, and we're going to do what we want to do. And nobody can stop us. And that's basically what the lower court judge could tell the Supreme Court. You say, well, that's a lovely opinion that you have, but you know what? I'm here for life. I got tenure. I'm not going nowhere. You can't strip me from this bench. I'm stuck. I'm in this position for the rest of my life. There's not a damn thing you can do about it. And I'm going to sit here, and I don't give a damn what somebody's ruling was. You know, if he's going to do, like I said, the old Ori tennis rule, he's going to be like, I'm witnessing the behavior of this man in this court, in open court. The Supreme Court is not here witnessing this man's behavior in open court. I see how this man is acting in open court, and I don't give a damn how good he sounds on paper. This guy's an asshole. There's no way in the world I'm going to let this guy do what he's doing.